Number 13, TCR Sports Broadcasting versus WN Parker.
Good afternoon, Your Honors. Carter Phillips, representing the Baltimore Orioles and Masson. Your Honor, may I reserve 3 minutes for rebuttal, please?
You have 3 minutes.
Thank you, Your Honor. This case comes to the court in a particularly unusual posture. There has been a formal and final determination that the first arbitration in this case had to be vacated because of evident partiality demonstrated by the RSDC, by Major League Baseball, and by the Commissioner of Major League Baseball. Under those circumstances, the question then becomes, what's the appropriate remedy? Does the court have authority to do something, or is it compelled to send the case back to a forum that's already been determined to be partially evident?
Aren't you extending the evident partiality too far? Didn't it all only go to the Proskauer representation?
No, actually, the quotation from Justice Andreas's opinion is arising out of the failure of MLB and the RSDC to correct the evident partiality that was embedded in it. So it's not just the problem of the conflicts of Proskauer. It is the refusal to do anything about it that reflects a lack of concern for fundamental fairness, which, as the U.S. Supreme Court said in Commonwealth Codings, that's the fundamental requirement of the Federal Arbitration Act. And so then the question is, if you have a fundamental breach of the FAA, what do you do about it? Well, Section 10 gives you authority, the discretion to send it somewhere, and most courts, candidly, do not, no other court that I know of has ever sent a proceeding back to the same forum that's already been declared to be evidently partial.
So where would our authority come from? FAA 2, 10, or inherent powers? What?
All three of those. I think actually Section 5 might even be available. But, I mean, Section 2 clearly gives you discretion to send it to the arbitrators. We know that authority says the arbitrators doesn't mean you send it back to the same body. No court has ever done that. Section 2 obviously allows you, if the purpose of the contract has been utterly frustrated, which, again, the notion of fundamental fairness was the essence of this agreement, and it has been frustrated.
So are you claiming there's evident partiality even after the change of the attorney?
Absolutely. At some point, the Commissioner of Major League Baseball reached the conclusion that the Orioles should lose this case. And in the litigation in the lower courts, the Commissioner of Major League Baseball went on record explicitly rejecting all of the arguments that the Orioles made about how this arbitration agreement should be interpreted. He's made those statements in public, and he's taken that position.
Was that a position adopted by either of the courts below? It seems as if Judge Marks's decision was cabined very tightly to the representation issue, and I thought that carried through at the appellate division as well.
Now, all of those courts, Justice Marks says that it was the refusal to provide for any form of fairness, and that was a refusal by MLB and the Commissioner and the RSDC to engage in any effort
And
to
in
correct the problem.
in your view, that's not limited just to the refusal to engage, say, in discovery with respect to Proskauer's representation. It goes beyond that.
Right. It goes to the whole idea of allowing that proceeding to be conducted in a context where it is decidedly partial. And under those circumstances, we don't know when the Commissioner reached the conclusion he reached. But we know that by the end of the proceeding, the first proceeding, which was an evidently partial proceeding, his view was the Orioles should lose. And he has said that over and over and over again. So that partiality continues on to this day, and this court should not blink at it. It should say, look, partiality is. Ken Feinberg said this is evident partiality. Justice Acosta is 100% right that this is evident partiality, and there is a remedy available, which is the AAA under Section 8 of the agreement.
I'm puzzled by something that may be tangential, but when I read the agreement, it looks really more like an agreement, an appraisal agreement, rather than an arbitration agreement. That is, if the parties go through they can't resolve it, they go through mediation if they want to or not, and at the end of the day, it then gets referred to a body that isn't an arbitral body, it's a value-determining body. It really looks more like an appraisal agreement than an arbitration agreement. I know you've litigated it as an arbitration, maybe stuck with that, but it doesn't really read that way. And when I look at Maryland law, which is what the contract chooses, Maryland law seems to suggest this is an appraisal contract rather than an arbitration contract.
Well, the parties have treated it
Yeah,
all
I
along
get that. I'm
as an
wondering,
arbitration
I'm wondering
proceeding.
why.
I suppose in part because no one knows exactly what the nature of or source of judicial review is of an appraisal agreement. The Federal Arbitration Act obviously ensures that there is judicial review of arbitral awards. And at the end of the day, this, I mean, as written, I could imagine why you might run to the conclusion that it's really just evaluation and auditing kind of thing. But in context of how it got analyzed by the RSDC, both the first time and the second time, it feels candidly much more like, particularly the second one, much more like a true arbitral proceeding. Unfortunately, it's one that's the product of evident partiality, and the Federal Arbitration Act
Is that
tells you
because
exactly what
because
to
of
do
the,
in that.
I'm sorry,
I'm
is
sorry,
is
Ron.
that because of the choice of the methodology? The dispute over the choice of methodology? Is that what you mean?
No, I mean, obviously, I'm disappointed by the choice of the methodology,
Yes.
but the fundamental problem that courts should be worried about is the fundamental fairness of the process. And if the party in control of
No,
the
I'm
process...
sorry, I mean with respect to why it's more like an arbitration.
Oh, yes. I mean,
Because of the-
both what is the methodology, and then how should the methodology be applied under these circumstances. I apologize, I misunderstood
No,
your
no, thank
question,
you.
Your Honor.
Counsel, just to go back to your original statement that this is an unusual posture for this case, right? It comes up to us in sort of a strange way. Let's say we were to agree that the court would have discretion to send it to a different panel. What are we reviewing? I mean, there's really no decision below on that issue, right? There's a plurality, and then there's a concurring opinion that says something different.
Well, you have Justice Marx's decision at the outset of this that said he didn't believe he had authority to do anything other than send it back to the RSDC.
Right.
So at a minimum, you could say that's wrong. He
And then
clearly
what do
has
we do
that.
with the case?
Well, I think the right answer is the court should simply say what the Federal Arbitration Act requires, which is that this be submitted, as Justice Acosta said, via Section 8 under the agreement
But
to
who
a third
would
party.
be-
But
It would be the Supreme Court in the initial instance here that would be exercising discretion as to whether to send it to a different body, right?
Right.
And we would normally, that would go through the appellate division, we would review that for an abuse of discretion. So you would be asking us to make that determination here?
Well, it's not the end of the world if the court wanted to remand it to Justice Marks to exercise his discretion. Candidly, I think he was pretty put out by the process by which the initial ruling came out, and he said as much. And he just said, I don't have any authority to do anything about that. I do think as a matter of law now that the answer is clear. No other court faced with any situation like this has done anything other than send the matter to a neutral and impartial arbitration panel. I mean, the Fourth Circuit and Hooters could not be clear. They did it even before the arbitration. So for this court to go in a different direction, seems to me, will undeniably create a split
But
between
isn't
the
the-
Fourth Circuit and this court.
But
I'm
isn't the
sorry.
course usually to send it to a different arbitrator, not a completely different forum? That strikes me that that's where you're asking for something that would be unusual under the circumstances.
Right, but only on-
Especially when the parties understood, when they entered this agreement, the way the MLB works and what they were specifically asking this entity to do, which it had never done before.
But that's not significantly different than something that happens pretty regularly, where the specific arbitrator is identified in the contract, and it turns out that person is not available. Court goes to another arbitrator, goes to a completely different process. That happens all the time. What makes it unusual, obviously, is that this is a forum that has become corrupted through the evident partiality process that entered into it. And the question
Well,
is...
it's corrupted because there's no longer a commissioner that's as favorable to
Well, there's a
to
commissioner
your
who is
clients?
evidently partial against my client's position.
Yes, but it seemed that the prior commissioner was quite favorable to your side.
Candidly,
No one
I'm
complained
not
about
sure.
partiality there, right?
I'm not sure whether he was partial or not, and,
Well,
you know, if we
I
were...
read your briefs to say, to include statements to the effect that my concern is what happens with the Orioles.
That was in 2005.
But nevertheless, right?
Right,
Nevertheless.
look, I mean, I don't think our perspective on this was we were perfectly comfortable when we went to arbitration in the first instance. It is only after we were treated as badly in the first arbitration that it seems to me at that point, we now have evident partiality. It's a final determination. The question is there relief to be had there? The Federal Arbitration Act says absolutely there is. I think you should rule as a matter of law that this case has to go to a neutral decision maker at this point. If you felt
And then-
compelled to send it
And then
back.
how does the court decide what body that would be?
Justice Acosta explained that in his dissent. The catch-all provision for all disputes resolution in the contract is Section 8. So if you sever out the 2J provision, the rest, there's a non-severability clause in the contract, so the rest of the contract
That would
stays
be
in
the
place.
default.
So the default is send it through Section 8 to the American Arbitration Association, where you'll get an expert entity, because that's what the arbitration calls for all other
If we
disputes.
did, going back a little bit to something like Judge Garcia's question, if we did what you were asking for, the first part of what you're asking for, which is to say they had the power to send this to a different tribunal, is it purely then a question of law that we must do that, or are there facts that really require us to send, Judge Marks is retired, but send it back somewhere to somebody who has fact-determining power?
Well, I'm not sure, I think the only question would be, is there a mechanism under the settlement agreement for where this should go under these circumstances? And I don't think there's a dispute between the parties on that. Section 8 is the default provision.
No, I was asking something different. I was asking, or trying to ask something different. Assume that that's right, that it's got to go somewhere else if there's sufficient predicate. Presumably that predicate involves some facts at some point. Have those facts all been determined, or
Yes.
do we need to send it back somewhere for further factual
No,
information?
the critical fact in this case has been finally decided is that MLB, the commissioner, and the RSDC, which is just an arm of the MLB, have been found to be evidently partial, and there's no way to unring that bell. So you have an evidently partial entity, and so then so they're not available. So then the question is, where do you send it? And Section 8 tells you where you send it. It should go to the AAA. And obviously, if you send it to the AAA, candidly, this dispute will be over a lot sooner than if you don't send it to AAA, and we will continue to go through this process seemingly in perpetuity.
Thank you, counsel.
Thank you, Your Honor.
Thank you, Mr. Chief Judge. May it please the court. Derek Schaefer here on behalf of the Nationals. Your Honors, the first time around, Justice Marks found evident partiality in one discrete respect. You can find it in the record at 3839, rejected all other arguments by my friends for the other side as to why there was evident partiality or any other basis for vacature, indicated just how easily, how readily that evident partiality should be cured. So let's look at what's happened in the 6 years since. You had a newly constituted RSDC, the same one that decides all such disputes about fair market value and about television rights across Major League Baseball, decided this dispute. You had a change of counsel, not only by the Nationals, but by the RSDC. That happened twice because the Orioles didn't like the first chosen counsel, so they went to a second counsel at that point. 7 expert reports were submitted. A 2-day hearing was held before the RSDC. And then the RSDC's 47-page decision issued that Justice Cohen aptly characterized as extraordinarily detailed
So
and thorough.
in this instance, they originally contracted for a place for disputes to take place, correct?
Correct.
So you're arguing one person being disqualified did not infect forever or make it such that we should disregard an agreement that the parties reached in the original settlement.
That's exactly right. And to put a sharp point on that, they reached that agreement in Section 2J3 of their agreement. It was core to the agreement. It was right up front. This was the only way that all important disputes over rights fees could be decided was by the RSDC. And that was exactly what the RSDC did in this agreement. You can find that in 203 of the record. So that forum was uniquely competent to decide, as is often true for industry insider arbitrations, to
So
decide what its established methodology would be.
What about the repeated statements by the commissioner in between the first and second arbitrations that suggest this is a foregone conclusion? It's going to come out exactly the same way and so on. I mean, you wouldn't be too happy if Chief Judge Canataro had been saying how this case was going to come out unfavorably to you for the last month or two, I assume.
That's true, but I think what the commissioner was saying there was that the integrity of the process would need to be respected, that the RSTC's decisions would be final, as the parties had agreed they would be, not that there was a specified outcome, and here's what the number should be, just that the outcome would be entitled to judicial enforcement.
Well, would you, suppose he'd said the latter that you say he didn't say, that is, the outcome is going to be exactly the same. Would you then say we need to send this to a different forum?
No, I think you can look to what the RSDC itself said in explaining why it was not recusing. You can find it at 4450-51 of the appendix, that they have just as much integrity, just as much reliability as a judge who looks at these questions, says there's not basis for recusal. And in fact, they are independent. They are their own body that decides disputes across Major League Baseball. In most of the RSDC's cases, they're deciding have individual clubs essentially shortchange Major League Baseball by not having fair market value transactions, so it looks like they have less money than they actually have to contribute to Major League Baseball.
That sounds like an appraisal proceeding to me.
Perhaps, Your Honor, and I credit Your Honor's point, I do think that this is an arbitration agreement under the FAA. I think the parties have agreed to that. But the point is the appraisal is as between individual clubs and Major League Baseball. So you always have, when the RSDC is deciding these disputes, you have the interests of Major League Baseball against individual clubs, yet you have owners who are part of this whole framework. Their clubs will be subjected to the same established methodology, the same sort of determinations. That's exactly what Baltimore signed up for when they did this agreement. Extremely sophisticated parties, very familiar with this league. Their owner sitting on the executive committee of Major League Baseball goes to Congress, praises the RSDC for the work it does in these cases and all across Major League Baseball. And if you subscribe to what my friends for the other side are arguing, you would basically be invalidating everything that the RSDC does, because they always have the commissioner of baseball and Major League Baseball who can be somewhere in the ether of their cases. Yet these are arbitrators who do their jobs reliably, with integrity, no less than other arbitrators. And Justice Marks found all that. He rejected every argument that was made for why the RSDC's output was supposedly invalid, and he found one discrete basis for evident partiality that was completely and undisputedly fixed. Again, not just by the same RSDC upon return, but a newly constituted RSDC.
Do you agree with that holding, that the first proceeding was infected by some structural inequity?
To be honest, Your Honor, we disagreed with it, but we took our lumps and we wanted to get this matter resolved. And although my friend says that it was destined that Baltimore was going to lose, in fact, they mostly won. The second time around, they did even better in terms of the ultimate valuation. We are not huge fans of that, except we need to have a binding, reliable resolution by the RSTC, which also is going to decide these issues for other points in time.
I'm wondering only because Justice Acosta predicted that the outcome at the second proceeding had to be nearly the same as the one in the first. And his prediction became true, and it sort of suggests to me that maybe the unfairness goes beyond just the one that was identified by Justice Marks.
Well, Mr. Chief Judge, I think that that's an unfair critique by my friends to the other side, because of course, if it had been a much worse outcome for Baltimore, I don't think they would have been holding that up as a virtue of the second arbitration. It's the same established methodology that's being applied, the same basic inputs of what are comparable teams making off of their television rights, and you have basically the same numbers. The difference is you had projected numbers for the first arbitration. The second RSDC was looking at the actuals. But look at their work. I would encourage Your Honors to read, as Justice Cohen did, the 50-page decision by them at 5662, 5711. They go through every argument made by Baltimore, credit most of them, do their own independent work, and it's not a surprise that the basic number is somewhere in the same ballpark as the first, because again, it's the same established methodology, you're looking at the same market comps, and you're basically working through the parties' competing positions, which had not changed.
Can we talk about that
much.
judgment for a minute? Do you think it accounts for all set-offs and profit sharing? Like,
It accounts for the number that shall be paid under the language of Section 2G of the agreement. That's all the RSDC decides, and it gave the courts everything needed to decide what is the amount that shall be paid off the television rights. It says what the numbers should have been versus what the numbers were. It says 3 times what it's deciding as to the numbers, and so
so what are you asking us to do regarding the judgment?
simply affirm. I think this court should affirm. And I'd note that all justices...
So the
unan-
the RSDC had the right to enter judgment?
It did. I think this was everything that the RSDC
So it's
could
not
decide.
just valuation?
It's not just valuation. As to these rights, it's the amounts that shall be paid versus what actually was paid, and it is complete unto itself. All justices who've reviewed the second arbitration award have unanimously agreed on this. Justice Cohn so found, and he was unanimously affirmed. And so we would submit to Your Honors...
But what about the offsets?
The offsets could be left to a separate proceeding. I'm sure my adversaries are going to argue everything that they can...
Why
should
should
it-
they be?
Yeah.
Why
Why
should
should there
they?
be a money judgment now if we still have to do the offsets? I'm sorry, Judge.
Because I think that the RSDC did its work, and that it is complete work as to the value of the television rights and what those contracts should have been, and you can simply do subtraction to get to, I
But in
think, the
its
correct number.
decision, it says the authority runs no further than determining the fair market value of the rights at issue. Does not speak to a judgment.
Well, but my respectful submission to the court is that it is deciding what is the amount that should be paid pursuant to those rights, and you can, as you often have
But it's
separate
also an
litigation between parties.
argument that they understood their limitation.
Well, I think that they said 3 times in their opinion, at the beginning, at the end of their analysis, and then in the conclusion, what exactly the amounts were that, again, under the operative provision shall be paid. I think they were indicating that they thought their work was done, and I think that translates to a money judgment. If you were to disagree with that, Your Honors, all you would do is simply, you would affirm in all other respects and indicate that it is not yet a judgment that can be monetized and collected on. But if I may make just a couple quick points under the Federal
Before you
Arbitration
do, my
Act.
last question on that is, doesn't the agreement provide a separate procedure for disputes over payments of, the correct number of payments for the rights?
Mr. Chief Judge, in all other respects, Section 8 provides for arbitration of all of the other disputes, separate from Section 2, but that is my point, that the RSDC under Section 2 did everything that the RSDC could do to say in amount certain what was the value of the television rights that should have been paid, that shall be paid to the nationals versus what was paid, and I think that they are entitled to have their judgment enforced no different than another arbitrator.
Well, to the extent that it's declaring the value of the rights, but it didn't do the math with respect to what had been paid and what the offsets are, and there was that loan that was made, that,
That's been repaid.
advance.
That loan has been repaid. Justice Cohen so found and explained that, so that, but
I'm not saying it factors in, but it might. I'm just saying there are a lot of other things that go into deciding what the final money judgment should be in this case, besides what's the value of the rights, which is, Judge Troutman said, that was their charge for this arbitration, just determine the value of the rights.
I think that those other disputes, potential disputes that Your Honor is alluding to, are ones that will be litigated, as this case has been litigated until kingdom come by my friends for the other side. So I think that is a recipe for just having this litigation continue and continue in never-ending fashion, as opposed to having one chapter of this, at long last, more than a decade later, conclude, and then if there are going to be separate litigations about other aspects of the dealings between these teams at other points in time, that can be litigated, as cases are often litigated in parallel. That's my respectful submission. But as to the Federal Arbitration Act, which this case is being decided under, Section 2 provides only for reformation of a contract or rescission of a contract on such grounds as it exists at law or equity. No one in this case has offered a coherent, clear analysis of what the basis is for reforming or rescinding the contract as negotiated between sophisticated parties who understood what the RSDC was and how it operated within Major League Baseball, and did that with precision and with clarity. So I don't think that there's a basis under Section 2, and I don't think anyone has credibly suggested otherwise. Under Section 10, you have after-the-fact vacature. That's what happened the first time around, according to Justice Marks, and could readily be fixed. There's no basis to send it to a different arbitral tribunal under that. And Section 5 not only is inoperative because you don't have a mechanical lapse, you have the RSDC that does exist. It is performing its responsibilities. It's there to arbitrate this case, and it was reconstituted in time to do that, just as it's decided all disputes throughout Major League Baseball. Last, the Second Circuit has specifically held in the Solomon case, which we cite in response to the amicus briefs, that if you have a designation of an arbitral forum that is central to the parties' agreement, as it so clearly was here, as set forth in Section 2J, you cannot then have a remand to a different arbitral forum. And I think that that rule makes sense. It tracks what the Supreme Court has held about the enforcement of private arbitration agreements, and no court, with all due respect for Mr. Phillips, no court has held otherwise under the Federal Arbitration Act.
But doesn't that make sense so long as the parties identify the arbitral form as not corrupted? I mean, that's their point. It's corrupted, and that's not what they bargained for. They didn't bargain for a corrupt arbitral form.
I think that that is a grotesque caricature of what this tribunal was and what it did. And you have that from Justice Marks. You have that from a majority of the appellate division. You have that from Justice Cohen. The reality of the fact that you had an RSDC that did its work just as a fair arbitral tribunal would. You have the unanimous affirmance of that. You could leave for another case what you would do if there's a fundamental lack of fairness. My respectful submission in terms of the settled law on this and the clear text of the Federal Arbitration Act is you would vacate the award of such a tribunal and say that that's going to be the law of the case, and there's no prospect of a valid judgment ultimately issuing. And then if that keeps happening, perhaps extraordinary relief in that case might be warranted. This case is not even close to that in terms of where it falls on the spectrum. So I think this is an easy case for Your Honors to affirm, consistent with the settled law of the Federal Arbitration Act, and otherwise, New York would be holding in special disfavor industry insider arbitrations, which are commonplace. They're commonplace within sports leagues, as we have here. They're commonplace within industries. They are very valuable. The Second Circuit has specifically acknowledged in the Lucent case that there's value in having industry expertise. Who better than the RSDC to say what is its established methodology for valuing television rights among Major League Baseball clubs, and what's fair value for arm's length transactions? They know that better than anyone. But when you have industry insiders, you will also have ties that flow across an industry. It is likelier that they're going to have dealings with one party or another, as was true certainly with the Orioles here. And to say that you can then indict the tribunal that's been chosen based on evident partiality, not only to get one vacature, but then to disqualify the entire arbitral tribunal, would make New York inhospitable to venerable, well-accepted arbitration agreements and arbitration mechanisms like we have here. That shouldn't be the rule of law here. Thank you, Your Honors.
Thank you, Your Honor. My friend starts with Justice Marks's finding. His statement was, this complete inaction by MLB and the Commissioner objectively demonstrates an utter lack of concern for fairness of the proceeding that is so inconsistent with basic principles of justice that the award must be vacated. This is not a problem of a single arbitrator. This is a problem of MLB and of the entire institution, first. Second of all, there was no question what the second arbitration award was going to look like. It's within 0.02% of the first award. You can reverse engineer from a number and
Counsel,
get back to
that's
where they
really
are.
assuming that the conflict originally had an effect on the award. It's kind of a setup in a way, right? So if the award is indifferent the second time, then you're kind of reaffirming, well, the conflict must have affected the dollar figure the first time. But what they were only saying there was the appearance of, and I understand that's what they say in the decision, but it was the appearance of Proskauer representing these different entities that created the problem that eventually overturned that first arbitration award. So to say, well, you didn't get a different number this second time, I don't see the connection there. Because they weren't saying in that decision that that conflict affected the number the tribunal gave you. They were just saying it couldn't stand because of that, what happened there.
No, but what it did say was that the product of that process was poisoned.
Right,
And-
but it's
and
not
that's-
saying
that poison
It's not saying the number is,
No,
to use your
fair
phrase,
enough.
poison. So to say, oh, because the number stayed the same, it proves my point, I can't
Fair
follow
enough,
that argument.
but I don't need that, because the problem of the poison is the Commissioner and MLB, and they are the ones who made a final determination that the Orioles should lose at all costs. And that's exactly what happened, but the focus shouldn't be on the second arbitration. The question is, Justice Marks looked at the first arbitration, said it had to be set back, and then concluded he had no authority to do anything in that situation. But we know that frustration of purpose, my friend says, what's the legal basis? Frustration of purpose. Justice Acosta said it, The court in Irving and Avial have both recognized that that's an appropriate basis for sending a case to another tribunal. Even the Solomon case he cites himself, the court decided the question. It didn't send it back to the same forum in which that case had arisen. I don't want to spend a lot of time on the final money judgment, because I don't think you should ever get to it. But clearly, if you did, that is so far beyond what the Federal Arbitration Act provides. That's not what the parties agreed to allow somebody to just enter a judgment under these circumstances. And his concern about, is this litigation going to go on forever? Well, it's not going to end with, even if this court says affirmed. We've got a whole new proceeding that has to go on regardless of that. And as I said at the outset, at the end of my last remarks, the only way to get this to full closure, send it to a neutral forum, let that forum decide it, and then regardless of what gets decided, there will no longer be a basis for challenging anything in court, because that will be a fair and impartial ruling in the case. That's what we bargained for, fair and impartial. Once it became impartial, that's frustration of purpose. I ask the court to reverse. Thank you.
Thank you.